Anything on behalf of the defense?
Yes, Your Honor. At this time, I would move to strike Special Agent Johnson's testimony from yesterday, as well as Agent Chappell's testimony for failure of the state to disclose exculpatory information. There was a test that Special Agent Johnson detailed yesterday during cross-examination, of which we were unaware, that being that he extracted and evaluated what's known as the MFT, which is the master file table of the IBM ThinkPad computer. And in doing so, and I believe this was some time ago, he determined that, as our expert had determined, he found file timestamps that were in fact invalid. I don't know the exact mechanism by which he got the data. I don't know the exact results that he found. I do know that the information he provided, that being...
So there's no discovery violation there, and there's certainly no Brady violation there. Secondly, I would argue another reason there's no Brady violation is because there's no evidence of tampering. None of this is exculpatory to the defendant in any way. And if it was, what would the state... If the defendant's not happy with the state deciding whether it's exculpatory or not, well, the state gave everything to the defendant. The defendant has the computer, he has the image of what the state tested. Now, if the defendant's issue is with an expert and the reports that were provided, well, the defendant, again, is asking for these procedures, something that the court barred the defendant from getting because, again, pursuant to statutes that the state has gone through numerous times, it's been decided that these FBI policies and procedures, which aren't given out anywhere across the country, aren't going to be given out in this case. I believe the court in that ruling said that it was open for cross-examination. The defendant had the opportunity to cross-examine Agent Johnson and Agent Chappell on that. So the real issue seems to be that the defendant's not satisfied with the answers that he got based on what these agents told him. And I don't know how that's a discovery violation, but what I would say is as to these two tests, the defendant brought up this MFT test and the lack of evidence of a phone call, this all is included in the numerous terabyte of files, to quote Mr. Kurtz, the Library of Congress of information that we provided to the defendant in this case. All of that exculpatory information has been given to the defendant. And I'd be happy to answer any questions on the discovery process by the state and this allegation of yet another discovery violation.
The objections are noted for the record. In my discretion, I'm going to deny the motion to strike the testimony of Agent Johnson, deny the motion to strike the testimony of Task Force Agent Chappell, deny the motion to suppress the and strike the IBM laptop.
Understood, Your Honor. We would, however, move for immediate production of the master file table, which clearly has exculpatory information on it and is something that they have actually derived and are in possession of. I would also move the court to inquire of the state as to whether or not they are aware of other exculpatory information that has not been provided through discovery. We have gone down this road before, and it is, we shouldn't be here. This should not be the discussion that we're having 7 weeks into the trial, having Mr. Zellinger essentially say that, well, it's a drug case, you could have tested the substance yourself, and since you didn't, we didn't have to give you the test saying it's not cocaine. I'm trying to avoid us coming up against this with all of the witnesses we have to come.
Your Honor, I'm not going to even address the second half of that argument. I don't know what that's about, but I'm happy to give the defendant a copy of what has already been provided to him. And if extracting this master file table will help speed things along, I'm happy to give the defendant whatever.
Is it already in the materials that have been provided?
The defendant already has these materials.
That's not accurate, Your Honor. It has not been provided, and I fail to understand the argument that actually has. The master file table is something that a tool has to extract from a computer. It is not something that any two tools are going to produce in an identical fashion. There is a difference in the way that it comes out. So in order for me to cross-examine Special Agent Chappell on the master file table, for example, Your Honor, I can't take out the version that I extract and say, you're familiar with this, aren't you? Because he's not. He's familiar with the version of the MFT that he created. And just because we're getting the actual computer does not mean that we have the file table that's generated as a result of it. For example, there is an entire category of time registry on a computer that are the other 4 timestamps that Special Agent Johnson spoke about that you can't see in the computer. There's nothing you can do right now to see them. They are available in the master file table. And this is something that, this is not a national security issue. This is from Mr. Cooper's computer. We want the extraction that they perform.
Do you want to respond? Because I have no idea what all this is about, technological stuff.
I don't, Your Honor. I mean, what Mr. Kurtz is asking for is what he's been barred from receiving, which is the procedures for doing this investigation by the FBI. And I can find the court's order, but pursuant to North Carolina general statute, if certain procedures are divulged, there's this, in federal law, there's this law enforcement privilege, but in state law, this issue is that if the FBI gives over all the procedures, then all the child pornographers out there can figure out how to manipulate their computers to keep the FBI from going into it. And there's the national security risk. It's showing the hand of the FBI and how they investigate these matters. And we had an affidavit from an FBI agent, and we litigated this issue 8 months ago, I believe. And so at this point, the defendant has the material that we have. And I don't know how to change that view. I'm happy to provide the defendant with, if the defendant asks me for something, I will happily give it to our experts and they can provide him with specifically what it is. But I'm not trying to hide the ball here, but the only issue that we run into is that pursuant to the court's ruling, the defendant isn't entitled to these procedures, and that's basically what the defendant's asking for.
Judge, on one hand, Mr. Zellinger's saying that we have it. On the other hand, he's saying we're asking for a procedure that we're not entitled to, and I'm not sure how those two things reconcile. The bottom line is I'm not asking for a procedure. I'm asking for the product of the test specific to Mr. Cooper's computer. And I'm asking for that prior to my having to cross-examine agents who have worked with this data. For example, Judge, if every file stamp on a particular day, if every one of them shows as invalid, and that officer knows it, I should be able to go through that with them item by item and have them explain exactly why it is that that's invalid.